Well, happy Friday, everyone, and welcome. Thank you for joining us for today's webinar on trademark tips for scaling companies, Canadian and UK perspectives. I am Jennifer Januska, the Director of Data and IP for Protein Industries Canada. I'd like to begin with a land acknowledgement. I acknowledge that the head office of Protein Industries Canada in Regina, Saskatchewan, is on Treaty 4 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, and Lakota, and the homeland of the Métis Nation. We respect and affirm the inherent and treaty rights of all Indigenous peoples across this land, and will honor the commitments to self-determination and sovereignty made to Indigenous nations and peoples. A few words about Protein Industries Canada. As a federally funded innovation supercluster, we are focused on supporting the development of Canada's plant-based food, feed, and ingredients sector. We completed in 2023 our initial 5-year program, and through 53 technology and capacity building projects in that fund, over 600 new products and services were developed. Nearly $500 million of project value was injected into the Canadian economy. Over 300 new unique IP assets were developed, and over 10,000 direct and indirect jobs were created. We are proud to work with innovative companies across this sector, and I know that many of our members are in the audience today. Warm welcome to you and to those joining from the UK and elsewhere. You may be aware that late last year we announced a joint call with Innovate UK for collaborative projects between Canadian and UK companies. And we're looking forward to seeing the fruits of those cross-Atlantic collaborations, which kind of leads to the topic and the structure of today's session, having experts from Canada and the UK to talk to us about trademarks. We are delighted to be joined by two really experienced and knowledgeable speakers in this area. But before I introduce them, I want to briefly set the stage for why we care about trademarks and why we care about IP at all. A 2019 IP Canada report from our federal government found that SMEs, small and medium-sized enterprises with formal IP, that is registered trademarks or patents, were 3 times more likely to expand domestically, 4.3 times more likely to expand internationally, and 1.6 times more likely to be high growth companies. And a 2023 EPO report from the European Patent Office found startups with formal IP were 10 times more successful in securing funding. We know that these things make a difference and give companies an edge in tough times. Trademarks in particular are incredibly valuable and important assets, and some of the most venerable and well-respected trademarks come from food and drink, our sector. We think of examples like Quaker Oats, Heinz Ketchup, Twinings Tea, and perhaps the oldest logo mark still in use today is Stella Artois. I just learned this today, which has been in continuous use since 1366. I'm going to turn it over to our speakers. Jennifer Coe is a partner at Dipchand LLP in Toronto, both a lawyer and registered trademark agent with a background in engineering. Jennifer leverages her experience gained both in-house and in private practice. She has advised and represented clients of all sizes and a wide variety of contentious and non-contentious matters. And she has developed and managed global IP portfolios and strategies with her clients. Jan Vleck is a partner at Reddie Grose, based in their London office. Jan is a UK chartered trademark attorney and was an EU trademark attorney until the UK left the EU. Jan has extensive experience of helping large and small firms at different stages of their life cycle to create trademark portfolios to protect their brands as they grow and innovate. And Jan also has experience as a past managing partner of his firm. I am going to turn it over to you, Jennifer and Jan. Thank you.
Thank you very much, Jennifer, for that kind introduction. I will say that while we are lawyers, nothing we say today should be taken as being legal advice. We are just providing you with information that hopefully you'll find to be helpful. So we were told to assume that you know what a trademark is and the basics of trademarks. So what we hope to do today is to give you some things to consider as you develop your strategy for protecting your trademarks as you grow, perhaps even beyond the borders of Canada and the United Kingdom. We'll give you some pointers on which marks to prioritize for registration, where to file, and different ways to register trademarks. We'll also talk about filing strategies and global monitoring. So before we jump into what marks to register, I'll briefly review why you might want to register a trademark, since in many countries, but definitely not all, trademarks are automatically protected as the trademark acquires distinctiveness and goodwill through use. Registration has real benefits that should be kept in mind when deciding how best to protect your trademarks. In Canada, registration provides nationwide protection across all of Canada for 10 years, and it's indefinitely renewable by paying a renewal fee. And one of the greatest benefits is that registration gives you an assumed right to exclusive use of the trademark across Canada. So as a result, in litigation, the onus would be on the challenger to prove that the registered trademark owner is not entitled to the mark. Registration therefore serves as a shield against infringement claims for use of that mark in association with the registered goods and services. And to illustrate this, I'll just tell you about a somewhat recent Canadian case between Wenger, the company behind the Swiss Army knife, and Travelway, which is a Canadian distributor of luggage. Wenger brought a trademark suit against Travelway to expunge Travelway's registered trademarks and to seek damages for passing off an infringement of their common law trademarks, which had acquired distinctiveness prior to their registration of the marks. But Travelway filed for registration of their two logos before Wenger registered two of their three logos that were at issue in this case. Both companies' logos, as you might imagine, evoked the icon, the cross of the Swiss flag, which is pretty iconic. And as Wenger was able to establish common law rights in their trademarks, the federal court found for Wenger, and Travelway's registrations were expunged. The question that went up to the Federal Court of Appeal was whether Wenger was entitled to damages for Travelway's use of its registered but infringing trademarks. And the Federal Court of Appeal held that anyone who uses their registered trademark within the scope of its registration is immune from liability for damages or profits prior to being struck from the register. So in the case of passing off, use of a registered trademark is a complete defense to passing off claims, which are unregistered trademark claims. So Travelway was not liable for damages or disgorgement of profits and was not liable for passing off. So that shows you the power of a registration of a trademark in Canada. Registration also gives enhanced ability to enforce trademark rights in Canada. firstly, it dissuades others from adopting a confusingly similar trademark, but perhaps more powerfully, it gives the owner a cause of action that's not available without registration if a third party uses a trademark in a way that's likely to depreciate the value of the goodwill associated with the registered trademark. So it gives stronger and broader protection. It also opens up some enforcement mechanisms. It makes available monitoring of counterfeit products at the Canadian border. You can then, if you're registered, you can request assistance of the Canada Border Services Agency in detaining counterfeit goods. It also gives public notice of your ownership through the Canadian Trademark Register. So it'll appear in searches in examination of later filed trademark applications. It might also give you the enhanced ability to license a trademark in Canada to others. A license for registered marks are often more valuable to licensees because of the stronger rights that are associated with them. It would also give you the ability to initiate domain name ownership disputes and register .ca domains. Another important benefit is it may provide you, or it should provide you, with an exemption from the Quebec Charter of the French language, at least some of the requirements under that charter. The charter is a law that aims to protect the status of the French language in Quebec. Amongst other things, it requires product packaging and public signage in Quebec to be in French. But registered and common law trademarks are exempt as long as a French version has not been registered. But the law was amended in June of 2021 to narrow the exception to only apply to registered trademarks, and only if the French version has not been applied for or registered. And that change comes into effect on June 1st, 2025. So companies that do business in Quebec don't have a lot of time to comply, given the backlog of examination at the trademark office currently. So something to look into if you do business in Quebec. Jan, do you want to?
Yeah, if I could just I'll try not to repeat, but sort of emphasize some of the things that apply from the UK point of view, and I will talk, and I do have Portuguese and Dutch nationalities as well, although I don't practice there anymore, about the European angle, which is often important. One, emphasize that point about use versus comparison with use-based rights. One, use and reputation-based rights don't exist everywhere around the world. It was interesting. Jennifer actually used the phrase common law. Remember that effectively, if you'll forgive me, the Canadian audience, means places that are Britain or ex-British colonies. Most of the rest of the world doesn't have a common law system. They have something called unfair competition. Trademarks, clearly they cost money registering, but they don't cost very much when they last forever. They are enormously easier to enforce when you want to sue someone, because you don't need to prove that you've used it, that you've had a reputation, which in the UK at least can cost hundreds of thousands of pounds just to prove the reputation. It makes a dramatic difference. And sort of emphasizing, I know it was picked up on, that customs seizure thing can be enormously valuable. Yeah, most of our countries, in fact, particularly valuable into the EU, which has quite a sophisticated system, and a lot of things come through a relatively small number of ports, which are really, Rotterdam in particular is very sophisticated at swapping things. So I wanted to emphasize they are relatively cheap. They are significantly easier to enforce. They do scare other people because they sit there on the register. And something that wasn't touched on, it depends on the stage of your business, is an asset for investors. My experience is people wanting to invest in companies want to see it. I did a good long picking up a bit on Jennifer's point about those numbers, about companies that grow and everything else. I remember quite a while ago, I won't admit quite long ago, having a conversation with a friend who was in the investment space. He was a hedge fund starting out in that world. And I was querying it. And he said, well, certainly, I don't know if this remains the case, but at the time, there was a very influential Harvard Business School study that basically used it as a proxy marker of a well-run business, an IP portfolio. It wasn't necessarily just the IP. but it's part of the game. If you're trying to impress investors, for whatever the reason, it seems to be something they look out for. And so that would be something too. Obviously, it depends on the scale of your business. That may not be an issue. Very cheap relative to use trademarks to enforce, scare people away, and you are creating an asset. And I think that I won't repeat. I just want to emphasize those particular points.
It is so. There are benefits to registering trademarks, but they are costly if you're going to register them globally, like in many countries. So companies usually have to prioritize which marks to register. So some things to consider in deciding what to register and what not to register are what marks you actually use. So investors probably care more about protecting what you're already marketing than what is coming in the pipeline. So those would be proposed marks, because rebranding is really expensive. So if you, for whatever reason, if you're infringing or there's some risk, then you don't want to go down that road. Marks you would not want a competitor to use is another area that or another reason why you might want to choose certain marks to register, and what the mark is used for. So for example, if the mark is a house mark, let's say Google or Samsung or BMW, these are business names, those are probably high on most companies' list of priorities to protect, because you don't want to have to change your business name or have others encroach on it. Product names are another area that you might want to protect with trademarks. So marks like iPhone or Galaxy. And to some extent, you may also consider model names. So like iPhone 10, so 10 or S20 for Galaxy or Samsung devices. But you probably want to you probably want to prioritize flagship brands as opposed to some small release that might not be in the market for very long. Slogans are other marks that you might want to consider. For example, Nike's "Just Do It" slogan, or Disney's "The Happiest Place on Earth," De Beers "A Diamond Is Forever." So here you might want to prioritize everlasting slogans over like short-term advertising campaigns, slogans used in short-term advertising campaigns. And a lot will depend on how the marks are used or will be used in the future. So slogans that go in all marketing materials for the indefinite future, you might want to prioritize that over a minor product name or model names, for example. Jan, did you want to add anything?
Strap lines or slogans are very difficult to protect in the UK and the EU. Nike got in there quite early with "Just Do It." I'm not sure they'd get it as easily registered now, but that's obviously at the bottom end. I think I support that. One of the dangers, my experience, being honest, it tends to be more of a problem for patents where the costs are significantly higher, but it is a problem in my experience some people suffer from with trademarks, is effectively spending too much money at the beginning and then running out of money. One of the reasons to prioritize and think about this is to not get overexcited. You've just had a lot of money, you've had a particularly good year, and let's register everything inside. Trademarks, as Jennifer Januska said at the beginning, they potentially can last forever. What you don't want to do is do vast numbers of marks, and then when the first lot of renewal comes up, and 10 years later, you don't have the money and you end up losing everything. So I know it's a bit of a statement of the obvious, but be wary. One of the reasons to prioritize is to make sure you don't blow your budget. And these things have an ongoing commitment years down the line. And the comment about how the marks are or will be used, and this comes along, I think the point at the bottom of the slide, is sometimes think about what's an easier way of protecting it. If you put your house mark on everything, that then obviously it does put a lot of your eggs in one basket, but it means you probably only have to register that one. That's the key thing. Think about using it, and say if you have vast numbers of product names, you are going to have to register. You may need to register more marks. It's something to think about, is thinking about, do I really need all those names? Do I really need all those names? And obviously think a bit about backups. I know I do a lot of trademark work slightly in the pharmaceutical industry, where the costs are enormous because they're going in every country in the world. And we typically have at least 1 or 2 backup marks, and we do that at an early stage. And that's a slightly different dynamic. But it's interesting how, think about it. If you, well, I think it's almost a statement. Jennifer's example was a very powerful one of those mobile phone manufacturers. I can't even remember whether my phone, what series of iPhone it is, whether it's a 7, 8, 9X, but I do know it's an iPhone and I do know it's Apple. And and that's clearly because that's the branding they use on everything. And that's my point about how marks are used, is think about talking to your advisors. Lawyers, attorneys are often excused of just being a way of spending your client's money. This certainly is an area where we spend, I'm sure Jennifer's like me, spend an awful lot of our time trying to tell our clients how to best spend their money, how not to waste it on things that are not necessary. And sometimes a little advice on perhaps use this mark. The other comment I'd make is logos change. Okay, I know that was it 1366 Stella Artois, but the reality is most logos change over time. I was saying before we came on, there's a brands museum in London that has some of those iconic British food brands, their packaging dating back over 100 years. And I presume you have Coleman's mustard in Canada too, so the UK audience. Coleman's is a very old brand, but the packaging looks slightly different. It's consistent. You can see the thread, but it's different. They'll have had to register all the packaging, whereas the original Coleman's word still is there. So do think about those words. They tend to be the things that last forever. And also in the modern world, they tend to be the things that are picked up by internet searches. They tend to be, people go Googling or when you recommend things by word of mouth, you repeat the word, not the logo. I'm not saying logos aren't important, but words are often the key that gets easily remembered. I think that's, and Jennifer made that point. And keep reviewing this. The world changes over time. Things change over time. And I'm afraid it's a sort of regular, obviously trademarks don't need to be done every week or perhaps even every quarter, but it's something worth looking at with your advisors every so often. And particularly scaling up countries, you're launching new products. Often in my experience in some of your fields, is you start doing new products. You suddenly, well, that isn't what I had in mind. This particular slightly different, this pharmaceutical client of mine, they had a product. It was originally developed for very serious illnesses. And then it became clear, actually, most of the money was in cosmetic applications. And we had to rejig the trademark portfolio. Now, that was pretty easy because it was so obviously something doing, but that's part of the reviewing. Does my thing made, and reviewing also means you can drop things. You're no longer interested. You can save money. My experience is that in a lot of companies, for perfectly sensible reasons, it can be quite hard to drop a trademark once it's been registered because there's a lot of sunk costs in it. Now, I'm not saying you just throw everything away, but money can also be saved in the review by working out, well, I'm not interested and I never will be, and I'll drop this. So that's also part of the exercise. Sorry, that was a bit of stream of consciousness, but Jennifer's so organized, I'm picking up the bits after it. So talk to people, think about it and review it regularly, and think about, it is putting all your eggs in one basket, making sure your house mark is on everything. Your product marks are used a lot so that as the brand, what you want to be doing is protecting what the marketplace has learned to recognize as yours. If take Apple and Samsung is on everything, the market has learned to look for that. And they're in a very powerful position to go after anybody who does something who gets close to them, and they need to register what the market has learned to protect. So that's back to you, Jennifer.
Sure, and I guess just a caution on that. Yes, use the marks often, but take care in how you use them as well. For example, trademark should be used as an adjective and not a noun, because you don't want to genericize the marks. Otherwise, you will lose rights that way too. So one I guess popular example is Kleenex tissues. So it should be Kleenex tissues and not just Kleenex. I know the company fought very hard to regain distinctiveness of Kleenex. I think they initially didn't use it in the best way. So they were risking genericization of their trademark Kleenex. So yeah, just make sure you're using it properly when you do use it often.
One of my colleagues is involved on the Kleenex for decades, and yes, she'd say something similar.
So you've probably seen the word trademark spelled in a number of different ways. Currently in Canada, it's spelled as one word, trademark. But up until 2019, it was spelled two marks with a hyphen in between. And then in 2019, we harmonized our spelling with that of the US. But I understand in the United Kingdom and in the European Union and probably many other countries, it's spelled as two marks, two separate marks with no hyphen. They are all referring to the same concept, but just as each country might spell the word trademark differently, each country has its own laws, and I guess this is somewhat reflective that each country has its own laws with respect to trademarks. Trademark rights are country specific, so a registration in one country does not grant you rights in another country. So just as you have to prioritize which marks to register, you also have to prioritize which countries to register in. And in choosing which country to register in, you need to think about a number of things. Markets, for one thing, manufacturing, where your manufacturing sites are and where others are, your competitors' manufacturing sites are. And transportation hubs is also another consideration. And I'll turn it over to Jan. He's got some really informative slides coming up. Do you want me to turn to those?
I'll go through some slides. So market is almost a statement of the obvious. The phrase I often use with my clients is don't just think about what you do, but think about what you'd be really annoyed if your competitors did as well, because that concentrates the mind. So markets, obviously, where you are now, where you think you'll go. All right, now I've got some numbers on markets, some of them which will follow in the next few slides. Manufacturing sites, obviously. Transport hubs, it ties in with that custom seizure. A trademark which covers the Netherlands and Rotterdam is really helpful in Europe. An awful lot of stuff comes through Rotterdam. Things like that are quite, but I don't give it. I have a colleague at work who does an awful lot of enforcement in the Middle East because an awful lot comes through Dubai. The port of Dubai has become enormously important. Shanghai, for a similar sense. Be aware, in your field, it was on the previous slide, but I'll refer to it anyway. We listed what I call risk countries. There's some interesting issues around that. China is simply a very large manufacturing site, and it's very common for copies or infringements to come out of China, is how I'd put it. Be aware of that. Brazil, slightly different, obviously in your field, I'm a big agriculture, obviously enormous agricultural country. It's also not so bad now, but it also is a country that has a history of people locally watching what's going on elsewhere, seeing someone register a trademark in the US, registering it in their own name in Brazil, and then you come along later and you want it in Brazil, and they say, well, I'm afraid you can only have it if you pay me money. Brazilian law has been amended in the not too distant past to change that, but be aware of that. Is people effectively pirates? They're just big countries where I pick them. The local distributor, it's happened to all of us who have clients who do international trademark portfolios, is discovering they're in negotiations with the local distributor. The negotiations aren't going. They say, I'm going to go somewhere else. And they turn around and say, well, you can, but the trademark is in my name. I've registered it. So that one comment, it's kind of like an oddity, but I'm afraid people will, in some countries, just to give you an idea of how broad spread, in the last 5 years, I've had that happen to a client in Hungary, India, China, and that's, I'm not suggesting any of those countries are particularly prone, but just to illustrate, it's something that happens. So if that was one takeaway, is be very careful with local distributors. I'm sure most of them are perfectly reputable, but it only takes one to cause an absolute nightmare for you. In that sense, also be careful with news outlets. Slightly different thing. One of my colleagues had an issue a few years ago. A company, a very large company in the UK, announced a merger before it registered the obvious versions of the merged name, and someone came along, and there was a very big court case here in the UK about 20 years ago, wasn't my client, when Glaxo merged with SmithKline. Someone had gone away and registered GlaxoSmithKline, and they actually basically blackmailed the new entity. As it happens, they lost the case because the courts in the UK considered it to be blackmail and forced them to hand it over, but it will still have cost them money. I've put up, and I'm not going to go through all the slides, but just to give you a feel, if we can go through quickly. And I know it seems a statement of the obvious. Germany's the top country. A lot of people aren't aware of relative sizes of population and indeed relative wealth. I didn't forget, almost everyone in my office has had someone, it's not a slightly different example, someone asked me to file a European patent covering Israel. Now, they won't make a mistake now, Israel's a lot in the news, but I'm not suggesting this one, but be aware of it. Yeah, there are some enormous differences. GDP, Holland is a relatively small country of 20 million, but some of the richest people in Europe, and it is a transport hub, so often it's a big area. And the slides, you'll see them after. It's just some of it you may be aware of, but just to make the points about populations and GDP. And these are the countries effectively I find my clients are registering trademarks, is this sort of thing. Indonesia is a big omission on that. But that's because not much seems to happen. Once you're going for Indonesia, you're already spending a lot of money, but it is a place that's very large population and in certain industries very important. That's Europe, just to give you a feel of where the wealth is in Europe effectively, is how I put it. Do you want to pop down? I think we're finished. Yeah, we're finished with that. I just wanted to make the point. Obviously, you can look at it some, and I'm sure you all do it. Be aware in your trademark, because often the business people, which is around this table, are all well aware of it. But sometimes if you're delegating to someone else to handle the trademark portfolio, they may not be quite as aware of some of these issues. And it's not straightforward. As I said, it might be there's a transport hub. Dubai is an import for some goods, is an important transport hub, but it's a tiny population and a tiny market. So I just wanted to flag up there's an awful lot of things, and there are quite big differences. And that was all data my assistant found on the internet, relatively easy. It's not difficult to check this stuff. So that's kind of some pointers as things to think about. Jennifer, back over to you, if I may.
Okay, and I just on the point about China, as I understand, there's practically no protection for unregistered trademarks in China. So unless you have a registration, there's not much you can do if somebody's using the trademark that you've adopted. And they also have custom seizures. So if somebody registers before you do, and then you start importing or exporting through China, that could be problematic for you, because then your goods could be seized. And so one of the things that is often advised for China is to register early if you're going to be dealing in China at all.
I'll make one comment on China. 15 years ago, there were people would ask the question, is it worth it? Will they be enforceable? No one is asking that question of me anymore. The Chinese court system will enforce trademarks. Maybe not as effective, in a different way. It's a complicated jurisdiction for enforcement. But the argument that used to be made, I won't bother because I won't manage to sue anyone in China. It's still not easy to sue someone, a local company as your foreigner, but it's possible. And that no one is saying now in the way they did 15 years ago, I couldn't see someone in China. You really can see someone in China. The court system is far more effective than it was 15, 20 years ago. They will, we regularly, not me personally, but I have colleagues at work who regularly enforce trademarks in China successfully. And obviously they're acting for European companies. So it's not the Wild West that sometimes people think it is. It's a sophisticated enforcement. And but you do need to have the trademark right to have skin in the game. You can't play the game if you haven't got the trademark right, which is a bit Jennifer's point. So it is worth thinking about that.
Yeah. And local laws are another thing to consider. Like I mentioned, in Canada, the Quebec French language laws might be a reason that you would want to register in that jurisdiction. So I'll go on to talk a bit about how to register trademarks and hopefully provide you with some tips for how to go about doing this. there are a few types or a few ways you can register trademark. The traditional way, or the most straightforward, I guess you could say, way is through national applications. You can always file an application in each country that you seek protection in for your trademark. But then you have to file the application and deal with the trademark office in the official language of that country, which might mean that you would need translations. And you would also have to pay fees in the local currency. You probably also have to appoint local agents to prepare and file the applications and to represent you in prosecuting the application. So these are additional costs. Another type is regional applications. There are a number of them. The European Union has one regional application system. Benelux is another one for Belgium, Netherlands, and Luxembourg. And then there's also an African regional system. And I'll turn it back over to Jan to talk about the European system.
The European system is the benefit. It's kind of, I was just thinking that I saw that slide. I can't remember the last Benelux one. The European Union system is so dominant in Europe. It's very powerful. It is, for the size of the market, it's very inexpensive. It's how, yeah, okay. In the sense, it's a similar size, well, however you define to the United States, bigger population, smaller GDP at the moment, but it's an enormous market. It's a central application. They're quite efficient way of proceeding. So it's something, it's a very common route in, and it gives you rights across the whole European Union. It does have its own issues. One big difference I would make compared to its examination system, and that's a benefit and advantage in comparison to the US one, is they don't examine to see if it conflicts with someone's earlier right. So they just check to see, is it descriptive? And they do that in lots of languages. So it is one place. You know, if you've got a mark that's descriptive in Hungarian, I suspect they won't pick that up at the USPTO, but they will pick it up at the European Union. But I hope that's perfectly sensible way of proceeding. I think it's a very powerful system. It's, in effect, it's a national application that covers lots of countries. It's one application, you file it, it gets examined, the office sits in Alicante, and it's an enormous proportion of our clients in the UK. Their first step after starting in the UK, which is their home market, is the European Union, and often the US as well, but the European Union, for obvious reasons, is the easy place to go. I said it's relatively expensive, relatively straightforward, very powerful enforcement mechanism throughout the European Union, and lots of people. So it's a bit of, being honest, if you're interested in Europe, it's a bit of a no-brainer. You really, there are very limited circumstances in which it makes sense to file separately in the countries in Europe. And I think the cost dynamic, last I looked, if you're interested in if you only want France, it's probably cheaper to do France. But you really only need, I think, 2 or 3 countries to then be cheaper to get the whole European Union. The only situations in recent memory where I've done that, only some countries, is literally because of that. Oh, it happens to be descriptive in Hungarian or whatever, and it's not anywhere else. It wasn't Hungarian, the example I'm thinking of, but I mentioned that, or because someone had an earlier right, just the one I had recently, someone had an earlier right just in Italy, so we had to go around it. It's likely to be, if you're interested in Europe, the first port of call would be a European Union application. It's quite difficult to go beyond that. As I said, there are special circumstances if someone else happens to be in Italy or whatever, but that they are relatively unusual. Shall I, while I'm here, talk a bit about the international system? Because one of the advantages of the regional and international is, and people, obviously cost is a big issue. Yeah, government fees are one thing, but if you're having to pay a lawyer, pay someone like Jennifer and I in every country, that quickly racks things up, and they can be surprisingly expensive in what I call the less competitive countries. If there isn't a competitive local profession, they do have it does sometimes seem to be a license to print money. It's fun when I go to international conferences, I'll tell you what, some of the Latin Americans and the people in the Middle East have the most expensive suits. They don't have a great deal of competition, and that's the world of competition. One of the big advantages of regional, and applies to application, I'll lead it in, is also administratively after registration. If you want to assign it to someone, you only have to assign one right, not 27 different European national ones, which again is likely to be significantly cheaper. You have one record on your database. You have one thing to renew as well, one renewal deadline. So one of the advantages that is sometimes overlooked is simply that procedural one of having less rights to manage. That doesn't mean if someone makes a mistake and you forget to renew it, you lose more rights too. But the general rule is people like the simplicity of one right to monitor one. Obviously, the reality is you'll have a portfolio. I meant one right for one mark. And obviously that's a particular advantage of the Madrid system, the international application system. The next slide has the numbers, which is, Jennifer, you just show it up just so people can see. To give you a feel of what's covered, the green is the members of the Madrid Union, the international trademark system. It is an enormous part of the world. Argentina is the only major, depending on your industry, is probably the largest omission. And for obvious political reasons, Taiwan sits outside most treaties as well. So Taiwan and Argentina are the two big omissions. The blue is the African regional system. You can see the international system covers an awful lot of places. The way the system works, if we can go back, Jennifer, the international system works is it piggybacks off your home national registration. You have to have started in your home country, or however you define that. And once you've filed an application, whether it's Canada or the UK, you file what's called a Madrid or international application. You don't need to go with all those countries. You pay fees dependent on how many countries you want. So you don't need to go all in at the beginning. You can decide, I want this selection of them, pay the appropriate fees, file the form, and effectively what was your national application gets shifted across and gets sent around the world to the various offices. And if they don't object, you don't have to employ a local attorney. So it goes straight through to registration. That's the big fee. It is safe to say if you designate China, you will get an objection. And they've set you about I think it's a month for response. But that, yeah, and you'll get an objection from the US often as well. Partly that we do because we're not as up to date in US practice. But what that means is it's much simpler. It gets through much quicker. In my experience, it's the really cheap way of getting a lot of countries. You can add countries later as you go on as well. So you start with the 15 key countries. A year further down the line, 2 or 3, you've done your review. You want to add a few more, you can add countries to it. You can't add goods and services, you can add countries. So it's a really powerful mechanism for doing it. It does have the biggest disadvantage is this link with its home registration. If you lose the home registration, I don't want to bore you with too much facts, but if it's effectively bound to the home registration for 5 years. So if someone attacks you at home and you lose that, the international goes down with it. There are things you can do to convert it. It works the other way. One of the first things we do when we're worried about an international registration is go looking whether we can still go after the home registration. So yeah, there are pros and cons, and your advisors can help you with that. Underneath, so in effect, a lot of what people like Jennifer and I do is helping people create what's the most cost-effective way through these interrelated treaties. And there's a lot we can do, and there's a lot we can do for not very much money in the scheme of things. A great deal less than one litigation gets you a reasonably competent trademark portfolio. Some of you will be aware, like I know you've had some talks on patents, I believe. Trademarks have what's called a priority term, similar to patents, except it's 6 months. Because trademarks don't have the same problem as patents of once you've disclosed that it's too late, you can miss it, but it's something to think about doing. Filing typically in your home, taking some advice and thinking about pushing it out abroad as you go. Bearing in mind the comments we said about local distributors and everything else, review it, thinking what you want. Not uncommon sometimes to then pick up and file yet another trade, the same mark. I'm doing an exercise at the moment for one of my clients. They're not very different industry to yours, is video gaming as it happens. And we worked out merchandising has become very, very profitable indeed. So we've had to tidy up the trademark registration because things they didn't think they were doing, and we filed a second one. But that's all part of the exercise of having a discussion, doing it. They're an interesting example as well, because they're a very successful company, they need investors, and investors are also insisting on this sort of thing. So it's part of the review. And I said, a large part of what Jennifer and I do, I know it sounds a bit self-serving, is to try and avoid you spending money on things you don't you don't need. That's kind of like a overview. Between all of these, it should be possible to come up with something appropriate and not too expensive. And there's an interact, and most trademark portfolios reflect a mixture of those rights. There are differences. One thing that's I put in the top thing, just because some of you may be familiar, and the US has quite strict requirements. Canada has relaxed them, as I understand it, about only registering marks that for which you actually use, which tends to mean US trademark registrations tend to be quite narrow. You don't get to just say medical products or whatever, or pharmaceuticals. You tend to have to say what it's for. Most of the rest of the world, it's not who used the mark first. It's a race to the trademark registry. And I think that's worth bearing in mind in all this. It's a race to the trademark registry for most of the world. There are defense mechanism. I touched on the historical. I haven't had an incident with Brazil recently, has to be said, but the Hungarian chap stealing my client's trademark. But it is worth bearing in mind. It's a race to the registry. And if someone else gets there in front of you, it becomes very difficult. Sorry, back over to you, Jennifer, if I may.
Okay. Just a note for Canadian applicants about filing international applications. I alluded to it earlier, but the Canadian Trademark Office, there's a huge backlog there right now. Actually, it's improving, but there's still quite a backlog. So that increases the risk if you file an international application where the basic application, the originating application, is filed in Canada, because there will be quite a time where you will be at risk if the Canadian Trademark Office rejects the Canadian application. You may lose the international application as well. Again, there's transformation that can take place, but it is a bit of a greater risk. So just something to think about. On the flip side, for foreign applicants, it might actually be an advantage to go through the Madrid Protocol, because the Madrid Protocol requires that applications are examined once the country is notified of the application within 18 months. So in effect, because Canada has to meet those deadlines, in effect, you get priority in the examination line over domestic applications or national applications, because they have to meet that deadline. So again, something to think about for foreign applicants.
I've said most of this. One comment for the British people on this audience: our civil servants often doesn't get a good press. Our trademark and patent offices are very, very efficient by world standards. You'll get an examination in a matter of weeks. They get apologetic. I sit on a committee at the UK IPO, and we had the so-called Marks and Designs forums this week. They're apologetic because they were getting close to the 10-day deadline for recording changes and doing things. It is well, at world standards, they are fabulous. I think it's safe to say, and I don't think any of them are on this call. They are very efficient at handling things, which does help the whole exercise quite a lot. This is just I've touched on it before. The typical approach for a UK company is clearly starting at home with their home, and then file a subsequent. EU is the obvious second. An awful lot of people, having said that, depends on your industry. My video game client went very quickly into Korea and the US because it's very large markets for its product. They were at the same time, so it is very specific. But this is sort of, in a sense, is not an uncommon way of dealing it. They did put in an international as well to at least partly, being honest, because they were conscious that they could be very big very quickly, and people might want to steal their marks. So that's a very common way through it. But I've said most of that already, I think.
Yeah, and for Canadian companies, also because of the backlog, while many companies will file in Canada first. Some may actually choose to file elsewhere, like the United States first, because they will get to examination faster and have some indication at that point whether the mark will take off or not, or their brand will take off in the market. So while I'd say a lot of companies file in Canada first, that's not always the case. And then they might subsequently file national applications elsewhere, claiming priority to the Canadian or whichever application they filed first. And international applications are also considered. I'd say, though, that I wouldn't say that there's a typical way that Canadian companies would file, or a typical strategy that they would follow. It really depends on what they're actually doing and what they want to protect. So moving on to some tips and strategies. I think one important step not to overlook when considering whether you're going to file or actually even adopt a trademark is to run a trademark clearance search. You want to do this to avoid infringing third-party marks, but also to get an indication of the registrability of the trademark that you're considering adopting before investing a lot of time, effort, and money into launching, advertising, and promoting a new trademark. As I said earlier, rebranding is often really expensive, and often more expensive than the initial adoption of a trademark. And if you have multiple candidates for a new trademark, you can search trademark registers or databases of the top countries that you're looking to file in. You can even do Google searches yourself to see if there's an exact match or something you think might be confusingly similar. And then once you've narrowed down your list and come to, like, let's say, your short list of candidate marks, it's still a good idea to have a full search conducted by professionals. There are professionals in this area that do the searches on the short, either your chosen mark or a short list of marks, so that they can not just about what other trademarks out there, but potentially other business names or trade names out there, and domain names. There might be web pages that indicate if there's use of a similar mark. And then a trademark agent or attorney can provide their opinion to you on the trademark's availability for use or its registrability. So if you have already, on the flip side, so if you've already been using a trademark for some time and you haven't received a cease and desist letter, and you have no intention of rebranding if you find any problematic marks, then it might not be worthwhile to run a clearance search. That could potentially get you into more trouble. So those are my comments. Yes, please do.
One, obviously, that point, Jennifer's last one is, if you've got investors or people who you said you'll tell them about problems and you uncover problems, that's I've certainly had that happen. As I said, they had no intention. I want to be. This is, unsurprisingly, with modern technology, this is an awful lot cheaper than most people think it is. Trademark clearance. Now, as I said, do it yourself. Most of the major patent offices have invested quite a lot of money in making really quite user-friendly searching systems. Clearly, your staff aren't professionals. I'd like to think Jennifer and I would do a better job of reviewing it, but it's a really good and no cash. The European Union office has something called TMView that does the whole European Union. And bearing in mind, that's a country where I touched on before, use rights aren't really that important. It's a race to the register. The UK IPO has a really good, really user-friendly searching, and they keep spending money on it. The USPTO has one. It's not as easy. It's a little more, I find it a little more awkward. It's less intuitive, let's put it that way. But there's an awful lot of quite good free stuff at the major offices. And then even if you pay someone to do it, it's surprisingly cheap, would be my comment. The analysis might not be. The advice on, oh, I found out this major problem, how to deal it. But the actual collecting the data is surprisingly cheap if you want the results, and we'll do something with them. Sorry to interrupt, Jennifer, but I just want to...
No, not at all. So on the next point, keep future business goals in mind when preparing your list of goods and services for your trademark application. A trademark application must list the specific goods and services that you want to protect, at least in Canada and the United States. And once you file the application with that certain list of goods and services, you can't later amend the application to add goods or services, meaning you can't broaden the application. So if you later want to add goods and services, you would essentially have to file a new application to cover those additional goods and services. So when filing an application, it's important to consider not only what your business currently offers, but what you're likely to offer in the future. Jan, did you have anything to add to this point?
The only point I made before is, and think about the other shorthand I give my clients is, think about what would really annoy you if your competitors did it. It's a slightly different version of the same question, but it gets people going. But otherwise, absolutely, this is standard everywhere in the world, let's be honest, and it's worth thought. And we all accept no one's got a crystal ball. The world changes, hence the comment, the next slide, about regular review.
Just another a quick tip. If possible, you probably want to secure domain names and social media handles before filing any trademark applications, because once you file the application, it goes on the public record, and then you might get squatters trying to take up the domain name and then go after you for a lot of money when you want to try to register the domain name or get the social media handles. You should review regularly and add countries and goods and services as your business evolves and grows. For Canadian applications, particularly national applications, try to use the pre-approved list of goods and services. We sometimes call it a pick list. If you can use it exclusively, this will get you much earlier examination in Canada due to the preferential treatment that's currently given to applications using the pick list. And the difference right now is 10 to 15 months, so it's considerable. And also, as I mentioned earlier, there is an advantage to foreign applicants filing through the international system due to the Canadian backlog. Global monitoring. Jan, oh, you're on mute, Jan.
Sorry, I put it on mute. You may have realized I've got a bit of a cough and I didn't want to torment you with it. I'll almost deal with the slide for commercial trademark watching services. I know I sound like a bit of a broken record with this. I think they're surprisingly cheap. The actual getting of the data, perhaps it's not a surprise, modern technology. I have a number of clients for whom we get what we say whether we want it. Typically, we don't want it weekly, we want it monthly. We get a report of, we set the mark, what's been at the various offices around the world. This is what people are applying. This is what's been applied for that's similar to your trademark. And then they can make a decision as to whether they want to take action against it. In most countries, it's easier to take action against trademarks earlier than later. Two reasons. One, what's called an opposition is typically much cheaper and easier than a court litigation afterwards. Also, the earlier you go after someone in their commercial cycle, the more likely you are to get them to agree to change. If you knock someone's trademark out at the application process, there's a reasonable chance they haven't actually started using it in the marketplace. So they aren't as committed as at the branding and everything else. So picking up people who are coming and doing things similar to you, it can be a very powerful, getting them early. It's a good time. Think about it yourself. If someone writes and asks you to drop a trademark that you haven't started using it, and they write and they've got sufficiently strong rights, you're far more likely to back down than if you've been selling it for 2 years and they've only worked it out where you are now. You just got much greater sunk costs, so they're worth doing. Having said that, the cost of the watch itself is not very much, but if you're going to do it, there is really very little point in doing it. Well, I suppose it's a bit of market intelligence depending on the mark, but there's not much point in doing it unless you're going to have someone review it and you'll think about taking action. I have the client, I do a monthly report for a client who has a reasonably well-known but pharmaceutical trademark in a particular area, and there's a certain amount of filtering for various reasons. There are aspects of the market pick up all sorts of things, they do probably once a quarter. I've got one going on at the moment. We filed an Indian opposition and someone's backed down. We get someone because we've hit them early and we're reasonably proactive. Relatively small amount of money has got someone who we would have been unhappy within the marketplace to back off. There's plenty we look at it and go, yes, but that's not really in our area. I don't really care. I'm not going to spend money on it. And it does allow one to do it. Obviously, that's commercial, but they do cost money. It's not very much. It's sort of hundreds rather than thousands. Depends on the service, but yeah, a worldwide watch. But as you can imagine, obviously they don't really work for logo marks, I should emphasize. But in the modern technology with searching, they're very effective. Obviously, you can also do it. I put up there, do it yourself. I also, for my major clients, have a Google Watch that sends me emails. But being honest, I like it too because it tells me what they're up to commercially as well. But I also have it on the brand, so things come along. So yeah, so think about it, and it's sort of the other side of the clearance is watching what's going on afterwards. I'm very conscious of time. I think we've almost got it perfectly, but people may have questions. I'll pass over to you.
Yeah. Okay, we've just put up some guides and resources that you might find helpful. So you can look at these if you'd like more information. And we're at the end. We're at the end of our time. So thank you very much for listening to us. We can take questions if you have any. Though Jennifer, I'm not sure if we can go beyond the hour.
Well, I appreciate all the wealth of information that has come through today, and hopefully we haven't overwhelmed the audience. I know there's been a very quiet Q&A window, but if you do have questions, please do not hesitate to reach out to Jennifer or Jan. They very graciously have given us this hour today, and their email addresses are on the screen. We will make these presentation slides available in case there was points that you wanted to go back through, and this session has also been recorded today and will be posted shortly to our Protein Industries Canada YouTube channel, where you'll be able to watch it there for a period of time. I want to thank our speakers very much for being with us today and delving into what's a difficult topic, but hopefully have given you some sense that there are ways to simplify this and to prioritize what's important for your organization and save money along the way. So thank you very much to the audience for your attention today, and appreciate your participation, and would like your feedback if there are future webinar topics that are of interest to you. Thanks all, and we'll end it there, but have a great day and a great weekend. All right.
Thank
you.
Bye-bye.